Imagine. You've built your entire life in Canada. Your child was born here, your career is here, your memories are here. Imagine. More than 15 years after you became a Canadian citizen, you open your mailbox and see a letter from IRCC. It says, "We are considering revoking your Canadian citizenship for fraud and misrepresentation." You read it twice. They say you might have lied about living in Canada. They say their records show you were continuously employed in Kuwait. At the same time you told Canada you were physically present here. The shock turns into panic. How do you prove where you were in 2003, 2004, 2005? When most companies only keep records for a specific number of years? How do you defend yourself against a phone call made to your old employer in another country? A call you never heard, a note you never saw. Let us find out all the amazing details of this fascinating case.
This is the case presented before the Federal Court of Canada. Mirza, tell us more about this case. It sounds like a nightmare.
A woman who became a Canadian citizen in 2007 was told in 2024 that her citizenship was being revoked for misrepresentation, mainly because IRCC believed she had been working in Kuwait during the period she claimed residence in Canada.
Wait, wow. How did IRCC even get involved so many years later?
Her file was flagged in 2014 when CBSA got a tip about citizenship fraud schemes involving her husband's name, and an investigation was completed that same year, but IRCC did not notify her about revocation until 2023.
So what was the supposed misrepresentation under citizenship application, Mirza?
In her citizenship application, she declared 166 days of absence from Canada between July 2003 and February 2007, but IRCC later pointed to a LinkedIn profile and an employment verification showing continuous employment with a major international brand in Kuwait over those years, and treated that as evidence that she must have been outside Canada more than the declared period.
LinkedIn? They used a LinkedIn profile as evidence. Really?
Yes, IRCC's case management branch found her LinkedIn profile saying she was a medical delegate in Kuwait from 2002 to 2009, and then an analyst at the Canadian Embassy in Abu Dhabi phoned the employer's HR to confirm that employment and recorded it as continuous.
But does continuous employment automatically mean she was physically in that country the whole time?
That was one of the core problems. The verification never probed whether continuous employment could include maternity leave or unpaid leave spent outside the concerned country, and the court later noted that the employment contract acknowledged that continuous employment can still include leaves.
How did she respond when IRCC finally contacted her?
In 2023, she received a request for information letter. She denied wrongdoing, asked for details, and highlighted her deep roots in Canada. The licensing she acquired in her profession, professional partnerships, property ownership, and family life, and even the offer to provide additional documents upon request.
And then the formal revocation process started?
Yes, in May 2024, IRCC sent a formal notification letter under Section 10, Sub 3 of the Citizenship Act, setting out the alleged misrepresentation based on her employment and her non-disclosure of those absences. She chose to have the minister's delegate decide the case rather than go straight to federal court action.
What did she argue in her main submissions?
She explained that the LinkedIn profile wasn't precise about leaves, that the employer had flexible maternity and parental policies allowing her to stay in Canada during pregnancy and breastfeeding, and that she used unpaid sabbaticals to study and sit her professional exams in Canada. She also explained that due to record retention policies, she couldn't obtain very old records beyond about the period in perspective.
So why did the delegate revoke her citizenship anyway?
Well, the delegate said they were not persuaded she had not made false declarations or lived and worked outside Canada during the relevant period, gave little weight to her hardship and delay arguments, and essentially faulted her for not producing more detailed historical documents to prove her physical presence.
Wow. So what was the key legal issue when this reached the federal court?
A central issue was who bears the burden of proof. The court confirmed that the minister must prove misrepresentation on a balance of probabilities, and that the delegate wrongly shifted that burden onto her to prove her residency and justify special relief.
What happened? What did the judge say?
The court found serious breaches of procedural fairness. It's interesting to note that the delegate made credibility findings against her without an oral hearing, and IRCC failed to disclose the CBSA verification document, which was central to the case, so she couldn't properly challenge them.
Why was the lack of an oral hearing such a big deal?
Because when credibility is central and accepting her version could change the outcome, the law and fairness principle usually requires an oral hearing so the person can respond to credibility concerns, and the judge held that this applied in citizenship revocation as in other protection contexts.
And the non-disclosure, what exactly was withheld by IRCC or CBSA?
The actual verification record that would show who was the point of contact from the employer who spoke to the embassy, what questions were asked, and that the officer never checked whether continuous employment could include maternity or unpaid leaves. She only learned the identity later from the certified tribunal record and then contacted that person herself.
So what did the court do for this person?
The 9-year delay between completing the investigation in 2014 and initiating revocation in 2023 was inordinate. The court found that it seriously impaired her ability to gather evidence and amounted to an abuse of process that undermined the fairness of the proceedings.
Oh, really?
The court granted her judicial review, set aside the revocation decision, and crucially granted a permanent stay of the revocation proceedings, meaning the minister could not simply restart the same revocation case against her.
Mirza, now from a client's perspective, what should an applicant do?
A professionally qualified licensed practitioner knows how to navigate the uncharted territory and situations, explaining them thoroughly, connecting and referencing them with supporting evidence, and answering questions such as why, where, who, or what legally. With reference to this case in particular, continuous employment, for example, did not mean continuous physical absence, and the requirement of explaining why record retention limits make certain documents impossible to produce. If you have received a revocation or procedural fairness letter, you should seek legal help immediately. Deadlines are tight, and a carefully structured response documenting your situation, explaining explicitly, and challenging investigative assumptions can make the difference between losing status and successfully defending it.
Moving Life Immigration Solutions expertly handles every case on its merits. Check the Google reviews, check the content on the YouTube channel, give us a call, or email us your questions. Moving Life Immigration Solutions guides everyone professionally, strategically, and ethically. If you have not subscribed to our channel, please subscribe to stay connected. We will see you soon with another great episode. Thank you for being a great audience.